Hi, my name is Robert Chelle with Chelle Law, and my law firm assists physician assistants with employment contract issues. Today, I'm going to talk about the difference between a non-solicitation clause and a non-compete in a PA employment agreement. So, in any employment agreement that a physician assistant signs, there's going to be a section that contains what's called restrictive covenants. And a restrictive covenant essentially prohibits the PA from doing something either during or after the contract is terminated. Normal restrictive covenants would include non-disparagement clause, non-solicitation clause, and a non-compete. So let's talk about a non-solicitation clause first. So a non-solicitation clause will stop the physician assistant from soliciting usually patients, employees, other PAs or physicians once they leave the employer for a set period of time. Most non-solicitation clauses are somewhere between 1 to 2 years. And so some things to think about in a non-solicitation clause would be what the definition of solicitation is. Most of these clauses will not define necessarily what is considered a solicitation. So in my mind, soliciting would be, kind of making active steps or taking actions that would initiate contact with patients, employees, or other, providers. An example of that would be, let's say you're, in primary care, you download a patient list of everyone you've provided care to, and then either immediately after or even maybe in your last few weeks of the employer, you blast out an email to all your patients saying, I'm leaving this practice, starting a new practice, please come with me. That would be prohibited by a non-solicitation clause. Another example would be, let's say there's maybe an MA or an RN or front office staff that you really like and vibe with, and you're starting at a new practice and you want that person to come with you. Maybe you would say, hey, send them a text that just says, hey, as you know, I'm leaving. I'd love for you to come work for me or my new employer once I leave the practice. A non-solicitation clause would prohibit that type of activity. So text messages, voicemails, direct messages through social media, these are all provable things that if you're going to solicit someone, if there was some kind of litigation, they could get access to. It would be clear that you were, soliciting people. Now, as far as patients go, you can't dictate who someone's healthcare provider is. So if you leave the practice and you have a patient reach out to you and say, hey, here you're leaving, I'd love for you to continue to be my, provider, you can give them the information of, all right, here, because you didn't initiate or, make any kind of solicitation efforts, the patient came to you first. So, if someone asks you straight up, hey, I heard you're leaving, where are you going? It's not like you have to clam up and not say anything. You can just give them the information. And then it's up to the patient if they want to come with you or not. Now, as far as a non-compete would prohibit you from working as a PA for a specific period of time within a specific area. So normally most non-competes are somewhere between 1 to 2 years, and then would prohibit, the PA from working as a PA maybe for 5 to 15 miles from their primary practice location. Some considerations when determining whether a non-compete is reasonable or fair. One, does it specifically list the specialty that the PA is in? So let's say you're a PA in orthopedics. Does it say you can't practice as a physician assistant in any specialty? Or does it say specifically you can't practice in orthopedics as a PA within this? You want to limit it to as much as possible. If you're working for a specific, clinic, office, whatever, hospital, you want to make sure that it's just in the specialty which would then allow you to, at least work in something else for however long the non-compete lasts. The length of time, 1 to 2 years is considered reasonable. Obviously, 1 year would be preferable. Anything above that would likely be unenforced. And then lastly, how large is it? This is going to be dependent upon your location. So 10 miles in New York City is going to be, prohibit probably thousands of opportunities, whereas 10 miles in rural South Dakota, you may have no other opportunities. So where you are geographically is going to determine whether 5 miles is fair, or 15 miles is fair, or 20 miles is fair. And then the state is also important as well. There are a handful of states that completely prohibit non-competes, but the vast majority of states in America do consider non-competes reasonable, or I guess enforceable, as long as they're reasonable. So that's the difference between non-solicitation and non-competition. Non-solicitation, you can't actively solicit business from past patients, employees, or other providers. And then a non-compete would stop the PA from working, in either their specialty or any kind of PA activities for a period of time within a specific area. If you have any questions about your employment agreement or independent contractor agreement, feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. Please like, subscribe to the video. We release videos every single day, and I appreciate you watching the video. Thanks.